Cottles, and this is Rosezetta Upshaw of the Law Office of Amy Einstein. So we're going to do, we've been here before, the bypass provisions that are presumed prior DCFS involvement. Okay, so does everybody have the slides? Okay. Okay, so I start with legislative intent, and so 361.5 overall is the reunification statute. And so the overall mindset is to reunify families. So it is difficult, if not impossible, to exaggerate the importance of reunification in the dependency system. So the B subdivision, those are the exceptions. So the reason I put the legislative intent in is because I think it's really important. We have a lot of new judges, bench officers, for us to take on that mindset ourselves. These clients are challenging, they're recidivists, so we don't want to shortchange them. We want to give them at least, the equal amount of attention that we give all our clients. So in the cases where the case law where they're ruled against, it's the mindset is more embracing the concept of, we don't have enough services to go around. These people are hopeless, and so we want to impress upon our judges the pro-reunification mindset. Also, the other reason I put it in is because there's a lot of discretion that is used in our case law, in our cases on a daily basis, but also when you get down to these statutes, we're looking at best interest standard. So that's discretionary. So we want our bench officer to be thinking in terms of pro-reunification. So our clients are entitled to notice. They're entitled to be noticed of any recommendation to deny reunification services, and informed that if the court does not order services, a permanency hearing will be held at which parental rights could be terminated. And that's 290 notice. It's 10 days out from the hearing, 5 days if the child is, let's see, 10 days out, sorry about that, you guys. 5 days out or 24 hours out, but it's 10 days out if the child's detained. Okay, so as far as the 30-day reprieve in between the juris and the dispo, that's really important. So the statute itself says that a permanency hearing will be held at which parental rights could be terminated. Then the court shall continue the proceedings for a period not to exceed 30 days. So in 30 days, a lot can happen with us preparing a defense to no FR rec. So can anybody tell me like some of the things that we could do in 30 days to build a case to avoid a no FR finding by a judge? No? Nobody?
Get down into a drug program, hopefully?
Yeah, drug program.
Address the reasons why family unification was terminated or not granted previously.
Right. So dig up old information. Yeah. So we can do a lot of things in trying to not only get the old information that we need, like the old findings, the old dispo orders, old certificates, family law orders, but we can also work on creating evidence that will help us in our defense. A party could get into a substance abuse program and be 30 days in to inpatient in that 30 days. Okay, the clear and convincing standard is super important as well. So The department has to prove each and every element of the no FR provision by clear and convincing evidence. And clear and convincing, we all know, is somewhere between preponderance and beyond a reasonable doubt. But I would like to just read one definition of clear and convincing. So, clear and convincing evidence is defined as that which requires such a high standard of probability such that the evidence is so clear as to leave no substantial doubt. So that's in re Isaiah C. But that's important to drive home to the bench officers as well, and keep that in mind when we're arguing. Okay. So Rosezetta and I did some practice tips. Get clear about the recommendation. Sometimes pleadings are not as clean as we'd like them to be. So there's not always an admonition on the petition. So early on, we should be trying to get our defense going. So early on, we should be trying to clarify whether or not the department is pursuing FR or a no FR rec. But don't go overboard and suggest no FR where they're obviously not going to pursue it. Okay. When an amended petition is filed, don't just submit on the new filing. Don't just enter a denial. Our courts have a lot of business going. You might be off on the side negotiating a juris, and someone's like, "Oh yeah, you enter a denial." Don't just enter the denial. Hopefully you've seen the amended petition. If not, stop. Don't enter that denial. Inquire about whether notice has been provided to the client, and the client's entitled to the same notice as they are the initial petition. So it's just, make sure that we're covering the bases, because notice is like one of the basic things that we really are entitled to, and I feel is essential, to protecting our clients' rights. Lastly, beware, a court can override the recommendation of the department for better or worse. And here's Rosezetta is practice pointers.
Alrighty. So issue spotting at detention. When we're looking at the petition, the detention paperwork, one thing we always look for is to see if there's a prior case. So a lot of times we think, oh, I'll check for conflicts. We should also be thinking about checking for potential no FR rec. So when you call out or check JCATS or the portal to see what the other case is about and who represented who, also try to find out what happened at DISPO, if there was a TFR, a TPR, etc., as some of those no FR bypass statutes will come into play. Another hint will be prior dependent children listed in the allegations. We've all seen allegations where it's a substance abuse case and they're saying mom tested positive on this date, and then they also list the names of other children who are not part of the new petition, but that have the birth dates, and the language indicates that the parent had a prior case and that there was also substance abuse involved with other children. That's another hint that there may be a no FR rec. And usually DCFS will put the bypass admonition underneath the language of the allegations. So it will say the department may recommend that no FR be provided, and that'll be directly in the petition. But again, even if it's not there, even if the department is recommending FR to a client that's not entitled to it, the court can still enforce a bypass provision and not order FR over the objection of your client, over the objection of the department, etc. Does anybody have questions about that? Alright. That's how I want you to look at it. Questions?
Do the notice requirements still apply if the court decides to do their own?
Yes. So as you're checking to see if it might apply, you're also checking to see if the department is providing your client with notice. So even if the department hasn't, you still want to give your client a heads up and start preparing them, tell them to get into programs. As we go forward, we'll talk about some of the case law. A lot of the case law talks about no FR, the burden that the parent has to provide testimony that it would be in the child's best interest that FR be provided. So,
But if DCFS is recommending reunification services, but the court on its own wants to deny reunification, what is the rule for notice that? Can you ask for a continuance?
you can. Your client is still entitled to notice. But I just want to make sure that no matter what, even if the department's not recommending it, even if you have no reason to believe that the court may order it, you still want your client to be prepared because case law is stacked against our clients. So I wouldn't rely on a notice defect for them to be able to get FR or get a decision overturned.
Could I just? No, I would stop the court and indicate that the client didn't receive notice of an OFR rec and that they're entitled to it. So I think that if it's this important, we consider, this is like, preceding the death penalty for dependency court. No FR could be an adoption in the end. I would definitely lodge an objection that our clients did not receive notice. But Rosetta's right, of course, that we should be looking out for that. But if there is absolutely no notice of it, yeah, definitely notice objection and request for a continuance. And the 30-day, if we're at the end of juris, if we're going on for a dispo and all of a sudden it's, the court's like, oh no, I'm going to go for no FR, when if that was not indicated, I'd be asking for that 30-day reprieve.
I have a question about the up to 30 days. Could the court theoretically turn around and say, okay, come back tomorrow?
Yeah.
And yeah, I just want to read it again because my reading of it is 30 days, but it does say up to 30 days.
Yes, up to 30 days.
Yeah.
It could be the next day.
So yeah, that's
It's
all
just-
the more reason to make sure your client is prepared, right? Because
I've never had that happen, but then
I've had that happen.
Yeah.
I've had it happen.
Come back the next day.
wait, raise your hand if you've had that happen. That's a lot of people.
So all the reason to start immediately, yeah.
So, I'm not sure what the right answer is to this, but I know Jackie Lewis, Judge Lewis, she used to say because you received notice at detention that there would be a no reunification services rec, there was your 30 days. So that you would not have a right to a further continuance after the adjudication.
Right. I mean, my argument would be that that's not the way the statute is constructed. Yeah, I mean, it says not to exceed 30 days, but I guess everybody's interpreting that too. Anyway.
And a lot of times the department will put that admonition in there and you'll look through and do your assessment and realize that the no FR bypass doesn't even apply. So it does seem like the department is kind of covering their bases and throwing it in the petition just in case.
And hence the clarity. I mean, I if it's not apparent and we're not given the admonition, I do double check. I do double check when trying to negotiate as well. Brooke, did you have-
Oh, I just wanted to point out that my understanding of 358A3 is that it's 30 days after juris. And the
Right.
goal is, or the point of the statute is to give you time to prepare because you're not assuming that the court is going to take jurisdiction. So once the court has made findings on juris, then that code gives you time to prepare for the disposition. So I think it is mandatory regardless of notice.
And that's my experience, and that's how I interpret it. Thank you.
Question on that?
Yeah, in response to a comment made earlier, I've actually had the court say, okay, I'll give you after lunch.
So they continued it. It was a custody case and they gave us after run.
Sometimes they'll say because it says up, most of the time our judge.
It doesn't use the words up to.
It says
Everybody's interpreting not till, shall not
But you
exceed.
do have a right for it, and because as an attorney, sometimes before they realize exactly you have the right to say, as Brooke said, you don't know exactly what's gonna happen with your saying, so that's always the excuse, because I assume, you know, your wizard would tell you not to sustain, and suddenly you're sustaining, so I would like to, you know, get the 30 days. Most of the time, a good hearing officer would give you 30 days, but if they really feel it's a loser, they may give you a week
Right.
or less.
And, right, and, you know, in the case, we're gonna go over Albert T., which is a 410 case, our very own Commissioner Marquette. Obviously, when he made his ruling, he felt like it was a loser, and he blew the application of the law in the process. And I think it's, I don't know, maybe this is too touchy-feely, but I think the mindset is this is a recidivist, they've gotten this, you know, these types of services before, why are we wasting our time, you know, gotta get out of court, gotta get to the next case. And so they don't sit there and apply the correct legal standard. So anyway, you know, you can consult your own, you know, law firm, but I honestly, I interpret it after juris, and you're entitled to 30 days, and I don't think I've had it interpreted differently, quite honestly, in the several courts I've been in, so. Is it my turn? Okay, so these are some practice pointers with approaching the client. So make sure to communicate to the client the import of the situation. So, you know, you can't make the client get it, but what you can do is communicate it and document your file. I like to provide my clients with a copy of the petition packet that I receive, and you know, I try to indicate to them that we'll be in contact because we're going to need to be, you know, gathering evidence or creating evidence, and you know, they need to participate. Don't just take, you know, the old reports on their face that you know, that this specific language was sustained and these orders were made, because we know that the social workers don't always get it right. We know that reports quite often just spit out the allegations as they were pled and don't take into consideration the sustained allegations. So that matters, you know, when you're looking at whether the parents made a reasonable effort to treat the problems that, you know, led to the prior jurisdiction. You know, and this is just in general, when a client resists, you know, going into treatment, often they'll say, oh, is it an admission of guilt? And so I found it useful to convey that it's strategy. I haven't had people balk on, you know, wanting to strategize. That I can use their participation in programs as a bargaining chip. And for instance, you know, and you know what I mean, if they're participating in, you know, a certain type of counseling, I can probably get this count dropped. If they're doing 12-step, I can get, you know, this drug count dropped, or I can ask that it just be testing in 12-step. That's an example of the type of thing. And I always indicate to my clients, over-enrolling is better. And when I'm going to be trying to negotiate it down, but it's hard to get in these programs sometimes. So over-enroll now, and then you can drop, you know, when you see what you actually have to do. And the only caveat to that is, when I'm speaking to my clients on the first day, I do look at that addendum, and I say to my clients, I'm going to look at what they're recommending, and then I'm going to tell you what I think. And they've got it. And I tell them what I think, and then I check the boxes on our NCR form regarding programs that I think they should enroll in. So, yeah, that's the practice pointer for that. So back to you, Rosezetta.
Thank you. All right, now we're going to get into the actual language of the code. For this presentation, we're looking at the bypass provisions that presume prior DCFF involvement. So for 361.5b3, there's three things you need. First, there was a prior petition because of physical or sexual abuse. Two, the child was removed, child or sibling, as a result of the physical or sexual abuse, and then returned to the parent. And three is now being removed again due to physical or sexual abuse. Everybody got that? Three things. Had the kid, lost the kid for physical or sexual abuse, got the kid removed, and then got the kid back, and then now you lost the kid again for the same issue. So that is a reason the court can deny FR services to your client. These three things have to be found true by clear and convincing evidence. And then the court will not provide FR unless there's evidence that is in the best interest of the child by clear and convincing evidence. And so we'll go more into how to present that a little bit later. Does anybody have questions about 361.5b3? Yes.
When we're talking about removal, we're not talking about detention, right? We're talking about dispo. So if they come in detained, but then we get them released to dispo, then it was like it never happened, right? In terms
Right,
of the
for the
removal
purposes
part?
of this, yeah. Great question. All right, so here's some case law to kind of clarify. So, unfortunately, this bypass provision can apply even when it's a different child. So if you had physical abuse or sexual abuse with one child, all three things happened, but it was a different child, the next time, B3 can still apply, unfortunately. And B3 is not limited to the case closing or the case remaining open. So if it's a subsequent petition on an open case, it can apply. If the case closed and a year later it happens again, it can apply, unfortunately. Moving on to B7. So B7 is like a J count of the bypass provision. So it says that the parent was denied FR services for a sibling because of re-abuse under B3, severe physical abuse for a child less than 5 under B5, or severe physical or sexual abuse under B6. So if a court found that B3, B5, or B6 applied and didn't offer FR in the past, the court does not have to offer FR currently on a subsequent case. And so again, 361.5C, the court will not order FR unless the court finds by clear and convincing evidence that FR is in the best interest of the child. And a little more case law. In Re AG, this was a case where the father was denied FR services to his daughter for sexual abuse. There were J counts for male children that were dismissed. So the court did not sustain the J counts that corresponded to the sexual abuse of the female sibling, and still denied FR. And this was upheld. So even if there's no J count sustained, the B7 can still apply. So in this case, the no FR for the daughter was B6 because it was sexual abuse. But then the court also applied B7 to the male children because the B6 applied. And so this is a case where it's happening in the same petition. And just to clarify, even though we think of it as a J count in the petition is not required. Anybody have questions about that? Yes.
I'm just curious if the 300J, was the 300J the only counts against the boys?
No, there were also physical abuse counts.
Oh,
Okay. And unfortunately, B7 also applies even when the parent is not the perpetrator of the abuse. And this is one of the reasons DCFS pushes to have the new or should have known language, the failure to protect language in the petition against a client who would otherwise maybe be non-offending. So even if your client didn't commit the sexual act or the physical abuse that's being alleged or that was sustained, if there was a prior denial, B7 can still be used as a bypass against them. So watch out for that. And fight hard to get that new or reasonably known out of the petition whenever you see it. Shocking. All right.
Unable.
Is that the same?
Unable.
Pretty much the same. Yeah, I think the court would interpret it the same for the purposes of the bypass provision. All right. Any questions about B7? Okay. Moving on to B10. So B10 is a prior TFR. If the court ordered termination of services for a sibling or half-sibling, and the parent has or guardian has not subsequently made reasonable efforts to treat the problems that led to the removal of the sibling or half-sibling, the court can deny FR unless the court finds by clear and convincing evidence that FR is in the best interest of the child. And this is where you need testimony. A lot of the case law points to the fact that there was no substantial showing made. Again, clear and convincing is a high standard. Not only do you want to encourage your clients to enroll in services, you also want to prepare them for testimony. So going back to the case that was cited before, the N-Rate AG, where the father didn't get FR because of the sexual abuse, and then even though the J counts were dismissed, the court didn't give FR for the male children. In that case, father had submitted documentation of programs. He had completed parenting, he had gone through sexual abuse for perpetrators, but the court found that he did not testify that he had actually learned or made any changes in his life. So we can't rely on even completion certificates. Case law is making it very clear that they're taking the clear and convincing evidence standard to mean more than just you completed programs. So you definitely want to prepare your client for testimony and be prepared to call your client to try to rebut the no FR bypass whenever it comes up, because it's always clear and convincing that FR is in the best interest. So in addition to doing programs and learning things, the court is also considering the history, the seriousness of the case, the bond between the parent and child, the child's need for stability, and also that FR services are likely to succeed. Questions, Jen?
So in light of your reasonable efforts point that you're making right now, that it takes more than just the showing of certificates of completion, what else could the parent show while they're on the witness stand testifying?
So some of the things I just listed: bond between the parent and the child, history. I think you want to do everything you can to demonstrate that FR is going to be likely for a lot of reasons. So that the parent has taken.
So to clarify, say a lot of parents can't afford or don't have their Medi-Cal or their insurance has been terminated. So what alternatives could they present to the court and counsel regarding the efforts that they, what other things could they take or do in that 30-day time frame between detention, or other things that they may have already been doing? Could they show you tell me, Lawren?
I can respond to that. So the burden's on the department to show that the parent did not make reasonable efforts. So just to clarify, so aside from all the things that you're gathering in order to create evidence, enrollment letters, because I made a list, eyewitness testimony. Say your client has, has become employed, has become consistent in, assisting with the care of the other children who may be in guardianship or something. get the guardian in to testify that mother or father shows up, takes care of the child, is no longer involved with the batterer. I mean, there is some case law that says, it was a drug case, but it was saying that, abstention is a showing of reasonable efforts to fix the problem. So we don't always have to have, and that's any case you're trying. You don't need formal evidence. There's eyewitness testimony, affidavits.
Church, maybe church.
Yeah, I mean,
whatever.
yeah, because it's evidence, and so you're trying to show this change. So which are other types of things? I'm sure you can think of other eyewitness testimony all on your own. But does anybody else have?
I would also think that looking at it from the perspective of the child might be really helpful.
Yeah.
So like what the child may want, or
yeah, and we get to we're going to cover the best interest part of the statute, and so we're going to talk about that. But yeah, I mean, if you've got a guardianship and this kid is, the parents become consistent and is, acting in a way, consistent with, say they were in a battered relationship before, they've cut loose the dad, or say it's just, failure to protect or failure to provide, and they've stepped up. All that can be shown, through, testimony or an affidavit of a caretaker or the guardian, and not all, let's face it, not all our clients are eloquent, so we may want to compile that sort of evidence. Does that answer?
Any other questions?
How do you show best interest when there's a brand new baby whose parent has been coming back and forth the system?
Can you hold that thought until we get to that part of the seriously? Is that okay? Fine. And then ask us again when we get to the best interest portion, unless you're ready to answer it. My mind's not there yet. Sorry. Okay. Okay. Yeah. Okay. So there's at the bottom where the notes are. There's split authority on whether or not, has everybody been in court and they TFR your client and then they move to the baby to deny services, and it's a feeling that it's just unfair. So Cheryl P. Is on our side. Cheryl P. is a case where the parents worked towards reunification of their two older children. They were TFR'd. And in TFRing them, they said they were close, but they just hadn't made sufficient progress in their programs. Then they turned to the third child, the infant child, and said that 361.5B10 applied because the parents hadn't made sufficient progress. So the court did reverse because the trial court did not apply the correct standard. And so, that's what I mean by the mindset of pro-reunification. And so the appellate court goes into the importance of reunification and that the parents should receive a chance to reunify with the infant because the court did not apply the correct standard. The department has to prove, and the court has to actually make a finding. This is very important. The court has to actually verbalize a finding that the department has proved by clear and convincing evidence that the parents have failed to, let me get the wording right, that the parents have failed to make a reasonable effort to treat the problems that led to the removal of the sibling or the half-sibling. So they have to make that finding by clear and convincing evidence, okay? On the other hand, we have In Re Harmony B. And In Re Harmony B states that the denial of services may occur on the same day as the TFR. So obviously, we're going to be using Cheryl P. In our efforts. So moving on to 361.5 B11. It's quite similar to the TFR statute. However, this is a prior TPR. The same thing, the TPR of a sibling or a half-sibling of the same parent. The court has made a finding that the parent has not made a reasonable effort to treat the problems that led to the removal of the sibling or half-sibling from the parent. Sometimes in the past, we've had people say, oh, we're going to relinquish right up front, we're going to beat that, we're going to beat that TPR, no FR subdivision. And unfortunately, case law says that that voluntary relinquishment does not beat that B11. So it does apply to a parent who voluntarily relinquishes a child. So at the very bottom, the difference between 10 and 11, or one difference between them, is that TFR only applies to a TFR that's previously occurred in California, so that would be the 361.5 B10. It only applies if the TFR took place in California. However, 361.5 B11 can be an out-of-state TPR, and you have the sites there. Okay, so since the court has to make a clear and convincing finding that the parents did not make reasonable efforts to treat the problem, I think that it's important to kind of look at this separately. We did provide copies of Albert T. And I'm just going to go through that case.
What?
Yeah.
Quick question on just the last slide.
Sure.
Does B11 apply if the parent didn't participate in the previous proceeding, or does that create due process issues?
And when you say didn't participate,
For one reason or another, they just weren't, they weren't noticed, they just never appeared on their previous case.
I would think it would. I didn't look up. I didn't look into that specific issue, but I would think that it would. I don't know. I didn't look up specifically about like alleged parent or
but their lack of participation
parent
in the previous proceeding should raise like red flags.
I would look at that though as a defense. If someone's just a bio parent, it might not apply to them. If someone's just an alleged parent, I don't know, it may not apply to them if they didn't have standing. Does anybody have an opinion on that? No.
I believe there is case law that says that it applies to alleged or bio parents who didn't even have the right to custody, and I don't have the sites off the top of my head, but there is.
Right. I think I did come across that, but so did you hear that?
I did. That's helpful. Thank you.
You can argue it, yeah.
Right, of course, definitely. Yeah, argue everything.
And just
make that record.
Okay.
So the case that I'm going to go into is Albert T. It came out of 410 in 2006, so it was pre-us. So let me get my notes. So this is a case that there's a mother and a father. There are two children, Alan and Albert. There's domestic violence, physical abuse, and inability and unwillingness to care for Alan pled on the initial petition. They went through mediation. In mediation, everything was dismissed from the petition, including Albert, except for one allegation that mother agreed to, that Alan had special needs and she was unable to care for Alan's special needs. So the DV and the physical abuse were dismissed. Over time, mother made some effort. She took a lot of different courses, but eventually Alan went to a permanent plan, and at this time mother still got Albert in her custody. At the PP for Alan, the department stated that mother's mental retardation, her inability to comprehend the danger that domestic violence poses to her and her children, compounded by Alan's diagnosis and behaviors, is what initially brought Alan to this court today. Mother had adequate participation in these programs, but has not been able to grasp the skills needed to handle Alan. Mother was found in partial compliance when the court TFR'd. After that, mother continued to be involved with Albert's father, and as a result of a domestic violence incident involving Albert, mother signed a VFM agreement with the department, agreeing to do parenting and individual counseling to address DV. So basically a voluntary contract where she keeps her child in her care. A few months later, Albert was voluntarily placed with an aunt on a VFR, so another voluntary agreement, and however, at this point, Albert's out of the home. Mother agrees to do the same thing. And she is participating in these programs all along. Eventually, unfortunately, they did file on Albert, and in the dispo, the mother, for the mother, the department argued that mother not be provided with services pursuant to 361.5 B10. And the court denied FR to mother, finding that she had a previous TFR, and the Commissioner Marpet just said, you know, this mother's just not getting reunification services. She's not entitled to it, and that's all he said. So the record, it was not a good record, understatement, and so there was absolutely no finding on that second prong. So, and that is why the court reversed, because the trial court had not made a specific finding by clear and convincing evidence that mother had failed to subsequently treat the problems that led to the initial filing. The argument on appeal was that the court could infer that because mother had failed to reunify with Alan, that she hadn't made reasonable efforts to treat the DV issue. When in fact, mother had actually completed 2 programs of domestic violence. Then the department argued that, well, she had not refrained from domestic violence relationships, so that's further evidence that she hadn't treated the problem, made reasonable efforts to treat the problem. And so the appellate court did not buy that argument, and that's where the language comes out that treatment is not synonymous with cure. So at least as far as, it's not so true with regard to drug use, but at least as far as continuing to be to have problems. You know, as you know, we're not trying to have perfect families, but mother continued to have some DV involvement, but the court still reversed in her favor. And so I urge everybody to read that case. There's a lot of interesting language in there. There's a discussion about what the problem that led to the removal of the child is. And so the reason I brought up that the initial pleading had DV in it, that DV count was stricken. And so that's one of the reasons why the DV was not necessarily considered what led to the removal of the child. It was considered to be an inability to care for Alan's special needs. Okay, so everybody read that. You've got a copy of it. So I'm going to move it a little bit. So you've all got another case, and you've got evidence of reasonable efforts to treat the problem, questions that I think are worthwhile asking, and documentation that's worth looking into. So the next slide is chronic substance abuse. The party has to be found to have a history of extensive, abusive, and chronic use of drugs or alcohol. That's the first prong. Chronic means persistent, constant, recurring. That's just a dictionary look at it, but most of the cases that I saw had, double-digit, well into double-digit use as they described on these cases. Has resisted prior court-ordered treatment for this problem during a 3-year period immediately prior to the filing of the petition that brought the child to the court's attention. Unfortunately, if you continue to use, even though you've sought treatment, that's considered resistance. The second case that I cite, Laura B., states that a mere relapse, however, does not constitute resistance. And so, can anybody state what the difference between abuse and a mere relapse might be? What the difference, how it's measured? So, frequency of use and duration of use are the factors that are used. So, if someone has a slip and they have, 4 dirty tests within a month versus, months of dirty tests, and it's obviously this thing's lasting, it's looking like that chronic pattern, then of course that's going to be considered resistance to the prior court-ordered treatment. Who's got a question? Yeah.
Hi, so I'm in Department 12-4, and on 3 separate cases of this exact issue has come up where I've had a client who has been in treatment and then has had a relapse. One, there was a death in the family, had a relapse, and then he re-entered treatment. And I can't remember the other 2, but it was a relapse. What I would consider a mere relapse as this case states. My judge has said that there is a newer case. He's not given me the case name, and I can't find it. Right, and he says that case law actually states that even one relapse, he's kind of alluded to the word VAR, like VARs, somebody. from getting FR or being found that they made a reasonable effort. So I tried to explain with my British attorney about this. She believes it's actually one of his cases.
Okay.
But I can't find it.
Okay.
And it's now happened 3 times, and my client is not.
So one dirty test. Is that what he's saying?
He says a relapse, 1 relapse. He's like specified 1 relapse. So 1 relapse, I don't know if that's.
Does he define
like
relapse?
30. No.
A positive test.
Yeah, one dirty, because for purposes of FR, just like, but not this test, because this is a different, the reasonable efforts toward, addressing a problem, like, that's supposed to be a bone that they're throwing to parents, It's I've heard, when there's FR underway and somebody tests dirty or misses a test, the court I'm in now has said, yeah, all I need is 1, dirty test to indicate that you are, it's still not, safe to return. So, and you think that it's in this particular finding, he's stating that I'm going to find by clear and convincing evidence that your client has not, he's made that finding, did you appeal it? Okay. Does anybody have input on that?
It doesn't sound like he's bypassing under this.
Right, is he
Not
bypassing?
under this case, I'm saying I believe that there's a newer case out.
Okay, well, I'll look into it. That goes against, do you have something? Do you have a question?
I just have a statement.
Yeah.
And Brooke, correct me if I'm saying this incorrectly, because I just want to make sure I'm correct in my comment. From what I understand, there's another county in California that is defining prior court order treatment that it could be like a criminal case that happened 2 years prior.
Yeah.
Which is a huge problem.
So. Yeah.
And so even if the child hasn't been born yet, and if they haven't completed their program through criminal court, then they could use that. And they are using that as a bypass.
Yeah. So I think that's true. Okay. So counsel just said that when it says in the first prong, up in the first prong, where I wasn't there yet, but I guess I was. So prior court-ordered treatment could be a criminal, like a DUI, a criminal order to do treatment, and your kid may not have even been born yet, and you didn't comply with that DUI order, then that could be considered resistance to prior court-ordered treatment. I think that's accurate. That's the way I interpret it. When I first started, the law wasn't exactly framed like this. They added the word court-ordered. It used to just be treatment. So the arguments would be about whether it was, like, how are they supposed to know, and like if you voluntarily try to seek treatment, why should you be penalized? So they added court-ordered to it, and in my reading of it, of the case law that I did read, yeah, it does include criminal court orders. And then finally, has failed or refused to comply with a program of drug or alcohol treatment described in the case plan required by section 358.1. That's the disposition case plan, on at least 2 occasions, even though the programs identified were available and accessible. So I've had someone try to say, oh, this person, they left this program, they went to this other program, then they failed this program. That's 2 times. Okay, so I don't read it like that, and I don't think case law reads it like that. I think Laura B. Has some dicta that says, that makes it 2 separate case plans, 2 separate occasions. So, hi. Yeah. Do you have a question?
I'll wait till you finish.
Okay. So yeah, and I was just concluding. That's the way I interpret it, and I think Laura B. Supports that. Yeah.
So I guess in theory, it's supposed to be an easier burden for parents to meet, but in practice, it doesn't always work out that way, does it?
Well, the reasonable efforts, so we're on to substance abuse. We don't have that, they don't have that prong for the substance abuse. Substance abuse, there's not a lot of good news, so I'm gonna scoot it out. So what I think should occur is, you should be trying to get rid of drug treatment orders, quite honestly, head them off. Try to suggest something other than a full program. So I'm going to move on because we've got 5 minutes. So the subdivision applies, keep going. 361.5C has the best interest standard, which is a subjective standard, but nonetheless it has it. So the burden shifts to us to provide by clear and convincing evidence that reunification is in the best interest of the child. Okay, and do you want to put it with both those? Do you have anything to say?
Sure, yeah, it's some of the things we already discussed. The factors, looking at the failure to respond to past services, the history of behavior, and then testimony by competent professionals. You can bring up anything that's going to help the court decide that it is in the child's best interest to have FR by clear and convincing evidence. And like Chris mentioned, it does seem to be stacked against our clients. With B10 and B11, the department is supposed to prove that your client didn't make reasonable efforts. But in my experience, the court generally makes that findings and puts the burden back on you to show by clear and convincing evidence that it's in the child's best interest. So in addition to submitting documents, you also should plan to call as many witnesses as possible. If your client has a long history, it's going to take a lot because they are looking at several factors, and history is one of them. Your client, if they're able, should testify and talk about what they learned. Several cases say, even though they completed programs, we don't know if they learned anything, and that's your burden, to prove that they did learn something and that it would be in the child's best interest, even though technically it sounds like that would fall under the department's burden to show that the client didn't make reasonable efforts to address the issue. I find that the court usually puts that on you. Are there any questions about that?
I was just going to say that under 361.5C4, so these are the factors that the social worker is supposed to look at, and I find that with that 30-day reprieve, because I think of it the way Brooke thinks of it, and that's the way it's been treated in the courtrooms that I've been in. I've even asked that the court order the social worker, when it's gone my way, when I feel like it's going to go my way, to get it into the report. I've asked that the court order the social worker to address the 361.5 C4 factors and write a supplemental report or write a dispo report for the contested dispo date. We have no time. Thank you, guys.
Oh, and before you go, to answer one question that came up, Jessica found the case law. Francisco G. v. Superior Court. If you're alleged, if you weren't there, then no FR still applies.
Sorry.
Thank you.
I'm preoccupied right now. Maybe that might be sitting right up front there.
And then find it, Andrew.
All right. Well, I need to go back anyway. Yeah, the detention.